We're going to be starting off today's webinar with Mike Kofahl from East Coast Environmental Law is going to be giving us our presentation about coastal policies in New Brunswick. And then the rest of the webinar will be an open discussion time about everything that we've learned and how we see policies and regulations moving forward in New Brunswick. And then we'll wrap up for the day. So without further ado, I will pass things over to Mike to introduce ourselves and get started with the webinar.
Great. And can you hear me?
Yeah.
My audio and video are working. Perfect. Well, I'll share my my presentation and just give a quick introduction to myself and the organization here. That is working. Perfect. Yeah, so I'm going to be talking a little bit about coastal policies and regulation in New Brunswick today. Just a quick note that I am actually coming to you today from Unama'ki, which is the traditional unceded and unsurrendered territory of the Mi'kmaq. And just a kind of note as well here that the laws that I'm going to be talking about today are settler and colonial laws. And I think it's really important to acknowledge and to remember that there are, in fact, many very much older Indigenous laws that have governed this territory that we now call New Brunswick for many, many centuries. And so that I just want to kind of remind ourselves of that fact and that we do have to make space and room for those laws as well. Just quickly about East Coast environmental law. We envision a future in which laws and legal systems within the region protect ecological health and promote environmental and climate justice. And so we work throughout the Atlantic region as well as at that federal level. And we do all kinds of things like providing education around environmental laws, engaging in law reform, and occasionally doing litigation work. Usually in collaboration with individuals and communities and organizations throughout the region. And I myself am a staff lawyer with East Coast Environmental Law. I graduated from Dalhousie in 2017, Dalhousie Law School in 2017 with certificates in environmental law and marine law. And so I focus most of my practice on issues related to the oceans and the coasts. And I have been fairly engaged in Nova Scotia on the Coastal Protection Act that is slowly working its way to completion here. So I'll talk a little bit about that experience and how it relates to the New Brunswick example. Just a quick agenda. I will talk very quickly about government jurisdiction in the coast, and then I'll talk about kind of 4 key areas of the law that are kind of subject matters within the law and policy. And they are aquaculture, pollution, and in New Brunswick with primarily land-based pollution, protected areas and protected ecosystems, and then coastal development. And I'll talk a little bit more about the policies that deal with building and developing the coast. So just a really brief overview, and I'm sure that most folks here, especially those coming from New Brunswick, already know what's really important and special about the coast. But there is about 5,500 kilometers of coast, which includes the Gulf of St. Lawrence and the Bay of Fundy. And so there's a really dynamic and diverse coastline in the province. And that dynamic coastline is home to a number of different ecosystems that serve really important services and functions. So for example, salt marshes in New Brunswick sequester carbon, sometimes called blue carbon, and that can be really important, and that sequestering capacity is much greater than terrestrial ecosystems. And New Brunswick's coast is also home to unique ecosystems and species that live in those ecosystems. For example, the Maritime ringlet, which is a coastal species that lives almost entirely in New Brunswick. It lives in northern New Brunswick and in southern Quebec. And I believe is only found in approximately 10 locations, and they are all specifically salt marshes. So it is a coastal species that very much depends for its survival on our coasts in New Brunswick and Quebec. Just a really high-level overview of federal and provincial jurisdiction. And we generally start at the Constitution level. Most people are probably somewhat familiar with Sections 91 and Sections 92 of the Constitution Act of 1867, which basically sets out the matters over which federal or provincial or territorial governments have responsibility. The primary ones for the federal government, at least as they pertain to the coast, are fisheries and federal crown lands, although there are many others. And then for the provinces, there's all kinds of potential powers that provinces have that are set out in the Constitution, but they include local works and undertakings, property rights, and natural resources. And just a note on kind of the coastal environment and the land there. Generally, from the low water mark out seaward to the 200 nautical mile limit, that's all federal jurisdiction. And then from that low water mark inland is generally considered provincial jurisdiction, except where there's pockets of federal crown land or the areas of federal jurisdiction. And then as a kind of general rule of thumb, and this is a general rule of thumb, not a, the law all the time, but generally as a rule of thumb, the area along the coast between the high water mark and the low water mark is considered provincial crown land. And that's important when we get into things like coastal development and building on that federal crown land or that provincial crown land. It's also worthwhile noting, and I had already mentioned this in the introduction, that there are other rights and responsibilities that apply in this coastal area. So we have Indigenous laws. We also have local government bylaws, also referred to sometimes as municipal bylaws in New Brunswick, and also private property rights. And occasionally corresponding responsibilities. But I'm going to mostly focus on kind of provincial laws in this kind of 20 minutes that we have. I do want to note, however, that Section 35 of the Constitution Act of 1982 does establish a constitutional duty for governments, so federal, provincial, municipal governments, to consult with Indigenous peoples before engaging in activities that could actually threaten their constitutionally protected rights, Aboriginal or treaty rights, as well as a corresponding duty to accommodate. And generally, the greater the potential impact, the greater the duty to consult. And so, for example, if there was an issuance of a permit, for example, a watercourse and wetland alteration permit, that could be a government action that can trigger this duty to consult and accommodate. So going right into the first kind of subject matter, which is pollution and pollution on the coast specifically. And I think most people know that pollution can be land-based and can be marine-based. And generally, the source of that pollution, whether it's land-based or marine-based, will dictate the level of government that's responsible. And again, as a rule of thumb, if pollution is coming from a land-based activity, it's generally within the sphere of the province to regulate that. And there's a whole number of laws that can apply to pollution, and I've just highlighted the Clean Water Act. There are also provisions in the Clean Environment Act and the Clean Air Act and other laws that equally apply to the coast, but this is maybe the most relevant and pertinent to coastal environment. And the Clean Water Act basically prohibits the release of a contaminant or class of contaminants into water, which can include coastal water, in a number of different circumstances, including if it would impact the quality, if it would endanger health or safety of persons or animals, if it causes property damage or damage to plants, or if it has various interferences with transport, business, or enjoyment and use of property. And a contaminant is pretty broadly defined. It can include a liquid, gas, solid, heat and sound or odor when they're foreign or in excess of kind of natural amounts that occur in that area. If they affect the environment or endanger health and safety or are designated by regulation specifically to be a contaminant. And under the Act, all pesticides and wastes are considered contaminants. This prohibition generally applies, but a person can release a contaminant into water if they have permission that's given under the Act. The second kind of subject area, and I think people in New Brunswick will be fairly familiar with this, is aquaculture. Generally, aquaculture involves the rearing of either fish or shellfish or sometimes marine plant species, often either on land in kind of contained units or in open net pens or similar structures in coastal waters or in estuaries near the coastal waters. And particularly impactful aquaculture is finfish aquaculture, which typically happens in these pens that you can see. Impacts from that kind of aquaculture includes the release of certain medications and feeds and pesticides and other wastes within those facilities, within those operations. There can also be noise and light issues. There can be pests, specifically bird species will often be attracted to those areas and cause a mess. There can also be impacts like dead zones where you have a large amount of fish in a small area and their droppings basically create these dead zones on the bottom of the water body, which can be really significant. And aquaculture is kind of funny in the sense that under the Constitution, the federal government has exclusive jurisdiction over fisheries. And so this has created some tension with respect to who actually should be governing aquaculture. Now, in New Brunswick, the federal legislation that applies is the Fisheries Act, and there are regulations specific to aquaculture under the Fisheries Act. But New Brunswick also has legislation that deals with aquaculture, and that is the Aquaculture Act. Because of this kind of tension between who should actually be governing aquaculture and the various aspects to aquaculture, there is actually a memorandum of understanding dedicated to the development and management of the aquaculture industry that was signed between the 4 Atlantic provinces and the federal government in 2021. So that kind of dictates the relationship there. Under New Brunswick's Aquaculture Act, the general kind of the rule of thumb is that no person can carry out aquaculture unless they've received a license. Additionally, there may sometimes be a lease or an occupation permit when aquaculture is located on provincial crown lands. And so when we're thinking about coastal lands, as I already mentioned, anywhere kind of between the high water and low water mark is potentially crown land, as well as kind of bays and other areas and bodies of water that are kind of surrounded or partially surrounded by land. There is also a registry, or there's supposed to be a registry under the Aquaculture Act, but as far as I know, that registry currently does not exist. There's also a number of policies that shape how governments make decisions around aquaculture, and those policies relate to different kinds of fish and where they should or should not be fished and how they're done. And I just want to kind of highlight this case and think a little bit about jurisdiction over aquaculture. As I mentioned, under the Constitution, federal government has exclusive jurisdiction over fisheries. And so there's always been a question of, is aquaculture a fishery? And if it is, why isn't the federal government exclusively regulating aquaculture? And so this was a question that was actually considered by the British Columbia Supreme Court in 2009, when a biologist, Dr. Morton, actually challenged the regulatory regime in British Columbia at that time. And the Supreme Court of British Columbia there found that, in fact, the regime that was in place there, which very much similar to the regimes found currently in the Atlantic region, including New Brunswick, was in fact outside of the authority and jurisdiction of the province of British Columbia there. And so there have been questions about whether there should be perhaps similar challenges in the Atlantic region. Now, the main reason that this case hasn't been applied to the Atlantic region already is that the British Columbia decision is not binding on other provinces. Another really important aspect of management and stewardship of the coastal environment is protected areas. And there's all kinds of laws that deal with protecting land and protecting coastal land and the marine environment. And I could do 3 hours of conversation about all the different types of laws that apply and how they work or don't work. So I won't get into all of that, but I will just quickly highlight some of the protected areas in New Brunswick, federally and provincially. So under the Oceans Act, there is one marine protected area in New Brunswick currently, and that is the Musquash Estuary MPA, which obviously is a coastal MPA. There are 3 coastal national wildlife areas in New Brunswick. So these are national wildlife areas that have a marine component. And there are also 2 national parks in New Brunswick, both of which have a fairly sizable coastal component to them. So these are all laws that are created at the federal level. New Brunswick also has legislation that deals with protected areas in the province, and these create kind of 3 main protected area types, which is parks, protected natural areas, and wildlife refuges. The Protected Natural Areas Act allows for designation of areas where the purpose is to protect the biological diversity. And there's kind of 2 classes of protected natural areas. Class 1 areas are really restricted and they basically prevent anyone from going into those areas, while Class 2 areas are heavily restricted and very few types of activities are allowed. And a permit is always required before they may occur. And so in New Brunswick, there are, I believe, 6 natural protected areas that are located along the coast. And I've identified them here, including 2 Class 1 and 4 Class 2. New Brunswick's Parks Act allows creation of parks, and these are areas that are set aside for use by present and future generations, and they often have a component of recreation and activity like that. But the Act does prevent certain activities from occurring, such as mining and quarrying, hunting and trapping, as well as prohibiting damage to species. And the Act does specifically provide some protection for certain activities where there's a removal of sand or gravel in a commercial setting from those parks. So there is kind of coastal specific protection. And finally, the Fish and Wildlife Act allows for creation of wildlife refuges and management areas within the province. Again, there being some prohibitions on certain activities without authorization. And you can find all of those areas listed in the schedules of the regulation that's created under that act. And so now we turn finally to coastal development. And you'll probably have noticed by now that there's really no one law that deals with the coast as an aspect or a component of the environment. It's generally a pretty piecemeal attempt to regulate the coastal environment and different coastal features. Either you have certain aspects of the coast protected under protected areas, or you have different laws that deal with contaminants or pollutions, or you have a law dealing specifically with aquaculture, but there's really nothing dealing with development more generally along the coast. And this is not unique to New Brunswick. In fact, it's pretty common in all of the provinces in Canada. So I suppose in that sense, there's nothing unique about New Brunswick. There are there's all kinds of laws that potentially deal with coastal development, and if you really wanted to start getting into things, there's all kinds of local government bylaws that could potentially apply, and then planning laws and policies. So I've really tried to identify kind of 3 core or crucial pieces to identifying how coastal development is done in New Brunswick. So under the Clean Environment Act, there is a regulation that prohibits, again, the release of a contaminant into the environment without an approval. There's also an environmental impact assessment process that's required in some circumstances, which may have coastal features or a component of a coastal environment being impacted. So as an example, if a project will alter 2 or more hectares of wetland in New Brunswick, including coastal wetland, salt marshes, then an environmental impact assessment is required. And so you can find a list of all the types of projects that would require an environmental impact assessment listed in Schedule A of the regulations. And there's a whole, this is a whole other area of the law that you could explore further with respect to potential implications for coastal development. And I think there's also a lot of room for improvement of how those regulations work and the types of projects listed there. And then the second law here, the Clean Water Act, and I've already, I think, mentioned it briefly, but the Clean Water Act does require a permit if someone alters a watercourse or a wetland. And I'll talk a little bit more about that in terms of some of the policies under these acts. And then under the Crown Lands and Forests Act, there's all kinds of different requirements for permits or licenses or rights of way or leases for projects occurring on Crown land. And again, this is where that Crown land between the high water mark and the low water mark becomes really important because that is, a key coastal area. So there's a number of policies that kind of help shape decision-making and approvals for coastal developments. The first really important one is the Coastal Areas Protection Policy, and I have another slide here, and I'll get into more detail. But basically what that policy does is it creates 2 coastal protection zones where certain activities are limited or restricted or prohibited. This approach to doing coastal protection is actually pretty common in some other Canadian jurisdictions. For example, in Nova Scotia in 2019, it's been a while now, but 2019, the government implemented and passed a Coastal Protection Act, which unfortunately is still not enforced because we're still waiting on regulations, and there has been some delays in that. But this is common in places like New Zealand and Australia and the United Kingdom and American jurisdictions like California, where the approach is basically to designate zones or areas of the coast that shouldn't be built in or should have development severely restricted unless certain criteria are met. And the purpose of that is basically to protect those future developments and ecosystems from things like storm surge and coastal flooding and coastal erosion, recognizing that those threats and risks are only increasing with climate change. And the second kind of key policy here, and there are others that are listed here, but the second kind of key policy is the Wetlands Conservation Policy. And a feature of this is that there's no support at the provincial level for activities that are in or within 30 meters of a provincially significant wetland. And one of the provincially significant wetlands are salt marshes, as well as some listed coastal estuaries. So this is also an important decision-making tool that the province uses. There's various guidelines for permitting and alterations for watercourses and wetlands. And there's also some policies under the Crown Lands Act or the Crown Lands and Forestry Act related to some of that licensing and leasing. So this is the kind of overview of how the Coastal Areas Protection Policy for New Brunswick actually works, or what it looks like. So you can see that there's 2 areas that are created, or 2 zones. Zone A is that piece on the left, and this is an area between I have it written here. It's the higher high water large tide and the lower low water large tide. So more or less between the high water and the low water mark. And within that zone, there's all kinds of activities that are prohibited, and those include infilling and excavation, dredging and disposal of that dredging material, various types of beach quarrying, and construction of structures like causeways, if the bridge is an alternative, and construction of groins. And other activities are allowed, and there's a lot of nuance here, but just generally projects that serve a public function that are necessary, certain surveying activities if the conditions that are set out in the protection policy are met, and I wouldn't have been able to fit all of those conditions on this one slide. Wetland restoration and rehabilitation activities. Again, there's certain conditions that are attached to those. Certain temporary access roads or permanent roads, boardwalks that have been approved, erosion control structures, except I'll point out groins. Groins are not allowed in this zone. And then certain accessory buildings where they don't exceed a certain size. And those accessory buildings are buildings that would be an accessory to existing structures already located within that zone A. And then in zone B, the same prohibitions apply. So the same ones with the infilling and excavation, dredging, etc. In this zone, which is 30 meters above zone A, some activities are allowed in addition to all of the activities that are allowed in zone A. So for example, soil disturbance for new or rebuilt structures or certain expansions. And again, there's specific conditions attached to that soil disturbance. And then there certain erosion control activities and structures are allowed in zone B, with the exception again of the construction of groins. So that's basically how the coastal areas protection policy works. One of the, I suppose, restrictions is that this policy is implemented through the watercourse and wetlands alteration regulation. So basically what happens is, to trigger this sort of decision-making process related to these two zones, you would want to be building a development, and you'd need to apply for a watercourse or wetland alteration. If you're not applying for that alteration, you're not in a wetland, you're not by a watercourse, or you're so far away from a watercourse that you're not altering the watercourse, you don't actually need that permit. And in that instance, the government isn't going to be doing this decision-making around these protected zones. So it's a potential gap in the way that the policy is implemented. It doesn't apply to, say, other decision-making processes, as far as I know, and as far as the policy sets out. So just a quick conclusion. I hope I'm not running too far over time here. We have a patchwork of laws, regulations, and policy that deals with coastal issues in a really piecemeal fashion. And part of the reality is that there's also federal and provincial and municipal jurisdictions, again, as well as Indigenous law. There's protection of the coastal environment largely relies on an approval system. Development along the coast is only restricted where the wetland or watercourse alterations apply, at least with respect to that zoning. One thing I will note that is potentially positive is that, unlike other jurisdictions in Canada, there is some provision for coastal access in New Brunswick's coastal regime. And so both under some of the provisions of the Crown Lands and Forestry Act, as well as the Coastal Protection Policy, there are some provisions related to trying to keep access to the coast, at least in terms of Crown land. So that is actually encouraging, that is not a feature of Nova Scotia's legislation, but it is kind of a best practice and feature of jurisdictions like California. So that is potentially an innovative and unique to New Brunswick. And then just as a general thought, I suppose, is that there is a greater need for public participation in the development and regulation and management of coastal activities. And a greater need for access to information, because a lot of the time those permits and applications are not publicly accessible, and it takes a great deal of effort to access them. So, and that's pretty much the end of my presentation. But I will note that we do actually have a public document that's available to folks in both English and French called "Environmental Laws for the Coast in New Brunswick." It's a part of our kind of broad summary series, and it's available on our website, so you can check that out. And there is actually, I meant to say this earlier, but I won't be sharing my slides because there's actually a recording of a longer presentation on coastal laws that I did that's available online on YouTube. I stopped sharing now.